Good morning. I am Carrie McReynolds, and I am a member of the Contra Costa County Bar Association Board of Directors. On behalf of the Contra Costa County Bar Association, I would like to welcome you to the 27th annual. We hope you are enjoying today's programs. Please don't forget to join us for our keynote today with California Attorney General Rob Bonta. This session, The Supreme Said It, Now What?, is a review of recent California Supreme Court cases impacting civil litigators and is presented by the association's appellate section. Thank you, Hanson Bridget, for your sponsorship and continued support of the association and its events. Our event and program sponsors are a very important part of our community, and it would not be possible for us to put on this event without them. Please support us by supporting them. A few quick housekeeping items, especially if you are like me and can't always figure out where everything is in virtual presentations. First, the materials and evaluation forms for this program can be downloaded from the Sessions page through the Files tab above the chat. Second, your attendance certificates will be available after the Thanksgiving holiday, as the association staff who has been working tirelessly on this event for months needs at least a few days before they can get them out. For further information on how to access them, please see the Facts tab on the event's main page. Third, for any assistance with technical difficulties, please also head to the Facts tab on the event's main page. Don't forget, while this program is pre-recorded, the speakers are available live in the chat to answer your questions during the presentation. They will also be available in the live Q&A immediately following the presentation. At this time, I would like to pass the program back to Gary Watt, who is the chair of the appellate section and will introduce his fellow speakers.
Thank you so much, Carrie. It pleases me to be here today and to have with me two great panelists. Justice Peter Siggins is here, and Justice Siggins was on the First District Court of Appeal, Division III for many years, and only recently retired. And I'm informed he's about to open his own law office. So keep an eye on Peter and the services he's provided, because he's certainly seen litigation from all sides and all perspectives, and can probably offer some great assistance. Also with me today is Don Willenburg, chair of the National Appellate Practice at Gordon Rees. Don and I have been giving MCLE presentation on a wide array of topics for many, many years. And it's great to be back here with him, although maybe next year we'll all do this in person. Let's hope so. So at this time, I'm going to kick it over to Don to start in with our first case, which is going to talk about the Privet Doctrine. Don?
Well, thank you, Gary. We're actually going to talk about two cases decided within the span of less than 2 weeks by the Supreme Court on the Privet Doctrine. The Privet Doctrine is about involves when a hirer hires an independent contractor. And a person or entity who hires an independent contractor ordinarily delegates to that independent contractor all responsibility for the safety of the contractor's workers. And as Sandoval versus Qualcomm says, the presumption is rooted in the reason why hirers hire contractors in the first place, and for a need for clear rules. And the notion is this, that first, that independent contractors, by definition, are controlling or ordinarily control the manner of their own work. And second, that hirers typically hire independent contractors precisely because they have a greater ability to perform the contracted work safely and successfully. A third presumption, which is not necessarily as expressly stated in the rules, is that we expect the independent contractors to know more about how to do their work than the people who hire them. A common example is a homeowner who hires someone to, name it, fix the roof, fix the windows, take a tree out of the front lawn. In all of those situations, we expect the contractor to be the one who has more knowledge of and ability to control the work and make it safe.
Well,
There
Don, we are talking about liability for personal injuries here, right? And this doctrine is there to provide a shield of sorts to the hirer.
Well, it does, but the prevent doctrine operates differently depending on the identity of the person who's harmed. Courts have traditionally given much more leeway to the hirer and focused more on the contractor, where the injury is to an employee of the contractor. If there's an injury to a third party, someone walking by the site while something happens, well, then the courts tend to go the other way and find some reason to pin liability on the hirer, because otherwise the fear is that the injured third party, who has nothing to do with their contractual relationship, will only have a remedy against a potentially insolvent contractor. Again, your tree removal service, your roof repairman. And so the law has distinguished those two things. The cases we're going to talk about today don't involve the independent, uninvolved third party. They involve employees of the contractor. And there, the concerns are generally biased or tilted in favor of the hirer. And one of the reasons for this, in addition to the policy reasons I just discussed, is that the contractor's employees ought to be covered by the Workmen's Compensation Act. And if they are, then they're already going to be compensated by what the legislature has determined is a fair amount for those injuries. And just as the worker would not have an independent tort suit against his employer, the contractor, he should not get a windfall and have a suit against the hirer as well.
So what was at issue in these two cases that what was so unusual that was going on that we have two Prevet cases come out within a couple of weeks of each other?
Well, for Sandoval, I think it was that the court decided, and this is very interesting and is applicable to many cases that have nothing to do with Prevet. The court decided that the standard Casey instruction misstated the law. And it did so in a way that prefers plaintiffs over the defense. So depending on your perspective, that's a good or a bad thing, but it is what it is. But I thought it's really interesting that the court here, and we're going to get to another case that talks about changing the jury instructions as well, said, hey, the standard jury instruction doesn't cut it, doesn't explain what we really need to explain. In this case, the question was, how much control did the hirer have? Now, I talked about the Prevet doctrine. There's an exception, imagine that, to the Prevet doctrine. And there's actually two. There's one where the hirer withholds critical information about a concealed hazard. That's the Kinsman case that is more frequently invoked in landowner cases, where the landowner doesn't reveal to the contractor a hazard that the contractor would not otherwise see. The second exception, and the one that our first case is going to talk about most, is where the hirer retains control over the contractor's work, actually exercises that control in a way that affirmatively contributes to the worker's injury. So there's three parts there. Retains control, actually exercises that control, and affirmatively contributes to the worker's injury.
That's the famous footnote in Hooker, right? The case Hooker versus Department of Transportation.
It may be a footnote there, but boy, it's in the text in a lot of cases since then. So that's right. So what Hooker decided was that even if hirers may owe unrelated third parties a duty based just on retained control, with respect to contract workers, more is required. Contract workers must prove that the hirer both retained control and actually exercised that control in such a way as to affirmatively contribute to the injury. Affirmative contribution is a big part of this case, and the court said affirmative contribution means that the hirer's exercise of retained control contributes to the injury in a way that isn't merely derivative of the contractor's contribution to the injury. The facts in Sandoval are these. The hirer was doing a power down of some electrical equipment. It hired a subcontractor or a contractor to come in for a portion of that work. The hirer definitely was in control of the overall power down, but not of the particular portion of the work that the contractor and this contractor's employee were involved in. So because it wasn't that close, the court decided, or a closer relation between what the hirer did and the injury, the court decided that the standard jury instruction on this was inadequate. I will mention something else about affirmative contribution that I think is really critical from this case. Affirmative contribution is a different sort of inquiry than substantial factor causation. And the court pointed out, for example, a fact finder might reasonably conclude that a hirer's negligent hiring of the contractor was a substantial factor in bringing about the contract worker's injury. Okay. But negligent hiring is not an affirmative contribution because in that case, the hirer's liability is essentially derivative of the contractor's conduct. So the court said that we have to modify the standard Casey instruction, which is, again, is at a level of generality that is a little beyond what the actual holding of that case and definitely not of Sandoval is. And the court says that to establish a duty, a plaintiff must establish that the hirer retained control over the manner of performance of some part of the work entrusted to the contractor, not just retain control in general, which people always say the general contractor has over subs. Well, yeah, you have some general control, but is it of this particular work, not just the general safety? And that the hirer actually exercised its retained control over that work in a way that affirmatively contributed to the plaintiff's injury. And so in this case, the court reversed, or the court determined that there was not a duty because the control that the hirer exercised was not over this particular portion of the work, and nothing that the hirer did established, or rather was an affirmative contribution to the injury.
So the upshot here for the broader application is that the elements have been around for a very long time. The jury instruction has been around for a very long time. And yet here is the court declaring that the instruction, the standard instruction in this case, was too general and not specific enough to do the job that the jury instruction is supposed to provide.
I strongly encourage all counsel to cite this case, and there are some others, that where the Supreme Court has said the Casey instruction isn't right. We all know how hard it is to get trial judges to issue any instruction that isn't a standard Casey instruction. And I, and I'm sure some other people as well, have briefs that say, but courts do this all the time. There are a number of cases where courts decide that no, the standard instruction isn't good enough, and so you need to issue another one. And so this may be, for people who don't necessarily deal in prevent issues, this is the big takeaway from this case, is that you can tell courts, no, trial court, even the Supreme Court says that the instructions don't track it all the time, and so you should feel free to do so as well.
Tell us about. Go ahead.
And if we do have a prevent case, the only thing I'd say is use the Casey instruction and tweak it to address the deficiency. Don't come in with something too new. That's the best way to approach it.
Although as of 2 weeks ago, I think you could go to almost any court and say we have to change the Casey instruction on this because the Supreme Court said.
Right.
Well, the Supreme Court directed the Judicial Council to come up with a new instruction.
Right.
Don, can you tell us fairly quickly about the Mathis case, Gonzalez versus?
The other case, Gonzalez versus Mathis, I'm actually in some ways surprised that this case made it to the Supreme Court. The holding in that case is that if there's an open and obvious problem or hazard, that the hirer is not liable for injury to the subcontractor's employee. Gonzalez versus Mathis involved a window washer who, for decades, had washed the windows at the Beverly Hills home of one John R. Mathis. You know Johnny Mathis. He had a home that was large enough that he had an indoor pool that was covered by a glass roof. He had a contractor who had worked for him for many years. In some ways, this didn't help the contractor's case because he advertised, we're really good at cleaning hard to find spaces and we can take care of this. And he'd also been there for a number of years. Well, because there would be no decision or no court case if someone hadn't been horribly injured. Yes, the contractor was on Mr. Mathis's roof and slipped off on something that was not a non-obvious defect. It was just he was in a narrow part of the roof and fell. Again, I'm kind of surprised that this case made it to the Supreme Court because it seemed to me that this was a fairly clear-cut example of what prevent is all about. No, the homeowner hired someone to wash the windows because the person who washed the windows is expected to know more about how to conduct that safely. In this particular case, though the court did not rely on this, the contractor made a big deal out of saying, no, this is exactly the kind of job I can do. I guess the third point or the other point I would make in this case is somehow this contractor didn't have workers' compensation insurance for his own business. And that's why he ended up suing the property owner, Mr. Mathis. But the court found that under a standard, straightforward application of prevent principles, that in this case, the hirer, in this case, the landowner, was not liable for the injuries. I will turn it over to Gary.
Thank you. Thank you. I'm going to talk about Natara John versus Dignity Health. And this particular case has to do with administrative law. And in this case, a doctor who's been brought up on potential disciplinary charges by his hospital and his hospital's board, and who is looking to have the hearing officer disqualified on the grounds of bias. And what he's dealing with is a statute, and the statute sort of sets the bias outcome. And the statute says that hearing officers and panel members in such administrative law proceedings, quote, shall gain no direct financial benefit from the outcome, no direct financial benefit from the outcome. So Dr. Natara John goes through the initial hearing He appeals to the board at the hospital, which affirms that he is going to lose his privileges at the hospital. He goes to the Superior Court and he says that's wrong. The hearing officer is biased. And he goes to the Court of Appeal and says the hearing officer is biased. And he loses all the way. And then the California Supreme Court comes in and he loses again, which makes it kind of interesting as why the Supreme Court would take a case. But I guess it's because not every application of the statute had been clear. And so it is trying to clarify what no direct financial benefit means. In this particular case, the hospital where Dr. Natara had the privileges chose who the hearing officer would be. And in this particular case, the doctor chose a procedure in which a panel of his peers would make the ultimate decision whether he should lose his privileges or not. So you've got a panel who's going to make the ultimate decision after the hearing. You've got a hearing officer hired by the hospital who is going to preside over these proceedings and make rulings akin to those which a judge would make. And the hospital hired the hearing officer, but the interesting wrinkle here to me is that Dignity Health owned the hospital and was paying for the hearing officer. And the hearing officer had performed similar hearing officer services on eight other occasions at various Dignity Health-owned hospitals. Nonetheless, the Supreme Court says there is no direct financial benefit here because it focuses on the selection process. And this is very interesting to me because the bottom line is the money's coming from Dignity Health, but instead the court focuses on the selection process and observes the following. It observed that Dr. Natara got to choose whether to have a panel make the ultimate decision or another process. And if he chose a panel, it comes with a hearing officer. The hospital, and not Dignity Health, decided which hearing officer would preside, even though Dignity Health is paying the hearing officer. And I think what really affected the outcome here is in hiring the hearing officer, the hospital had a contract that stated that the same hearing officer would not perform the same services at that particular hospital for a 3-year period. So he could do this work, but he couldn't come back and do similar work at that hospital for 3 years. And after discussing bias and the impression of bias and other wrinkles in the statute, the court says that under these circumstances, taking all of that into account, there A, was no presumption of bias, and B, on the merits, on a case-by-case analysis which applies, there was insufficient evidence of a direct financial benefit, notwithstanding the fact that this particular hearing officer would certainly aim to please Dignity Health, which owns so many hospitals in California and could be the source of future income as he roams around the state performing this work if he could get it.
Well, that's right, Gary. Isn't it that he actually did receive a financial benefit? And I mean,
he did,
that's definitely true.
And apparently it's not direct enough.
Not direct enough. One of the other things that this case made me think of when I read it was in arbitration, and certainly in many cases involving consumer arbitration or arbitration with employees, there is actually a presumption that the employer will pay the arbitrator, because there's the notion that it's unfair to make an employee pay half that cost or most of that cost or any of that cost because the employee could go for free to a court. And lots of times there, again, the arbitrators are repeat customers of various entities, and courts have found that is not enough to determine that there's bias.
What's interesting to me about this case, and Peter, I think you should help us explore this. But what's interesting to me is the court says in one line that Dignity Health is paying the hearing officer, and in another line says he worked on Dignity Health hospitals 8 other occasions in a recent time span, but never really comes back to the issue of payment by Dignity Health again, and just finds that there are some steps in between or some hurdles in between, and says this particular case is not a direct financial benefit case. Maybe Peter, you could share some enlightenment for us on this.
Sure. I think the court is looking at the reality that, as Don says, it's better that the hospital's paying for the hearing officer. That's where we kind of want to put the financial burden. But the other thing I would say is, I was a little mystified too why they took this case, because the outcome has been consistent all the way up. And it seems that the only thing they were really trying to get to was direct financial benefit means a direct pecuniary interest, and it's not the appearance. Because the opinion goes through a lot of effort to tie the result to the particular facts that were involved here, including this 3-year prohibition of retention at that same hospital, not necessarily by Dignity, but at that same hospital. So, we're left with kind of walking away saying, okay, the hospital chain can employ these hearing officers wherever they want, but they can't stick them in the middle of the same hospital all the time if the employee selects to proceed with his peers, I guess. I don't know.
And I guess as a final note on this, and then we'll move to the next case, is the court did actually overrule a case called Jakob versus Salinas Valley.
Right.
And that case has held that there's impermissible bias if there is, quote, a prospect of obtaining future work from the same hospital, a prospect. So, I mean, that's a pretty loose standard that got overruled. And maybe that was the driver of them taking review. But why don't we move to Daley versus San Bernardino County? Peter, you're going to tell us all about that case.
Sure. Daley versus Board of Supervisors of San Bernardino County is a case that deals with injunctions that are stayed on appeal. And I think most of us are familiar with the rule that a prohibitory nature, an injunction that is prohibitory in nature is said to preserve the status quo. It's effective immediately in the litigation. But orders that require an affirmative act, those that are mandatory, are automatically stayed during the pendency of an appeal. And there's a lot of lower court law on it. The Supreme Court rarely writes on it. That's partially why I think it's a good case to look at. In Daley, what happened was the Board of Supervisors filled a vacancy that arose on the board from an election of a member to the state assembly. A petition for mandate was filed by citizens that said, hey, you guys violated the Brown Act, our state's open meeting law. You essentially had some closed door discussions in seriatim meetings about this vacancy and filling it. It's invalid. So the trial court issued an order, and the order did essentially 5 things. It rescinded the appointment. The board's candidate was selected and seated at a board meeting. Petition for mandate gets filed. The court rescinded the appointment, directed the board to refrain from allowing the successful candidate to participate in board decisions, refrain from giving any effect to actions that were taken by the selected supervisor, to refrain from filling the vacancy pursuant to the county charter, and to immediately seat any person appointed by the governor pursuant to state law. So the board appealed, and they sought a writ of supersedious to seek a stay. And the Court of Appeals said that because the finding of the appointment was null and void, any mandatory directive in the order were incidental to that finding, and the order was really a prohibitory order. And then the Court of Appeal declined to issue a discretionary stay. The board then sought review, and the question on review was whether or not the order should have been automatically stayed as a mandatory injunction. And It's a
And Peter, just to be clear, for those who are not grappling with injunctions that much,
sure.
In state court in California, a mandatory injunction comes with an automatic stay if a notice of appeal is filed, whereas a prohibitory injunction does not. You can seek a stay, but you might not get it, or you might, but it's not automatic.
Correct. If it's an order that's directing you to do something, to do an affirmative act, it stayed. And so what the board did was they went into the Supreme Court and they said, hey, we want to file a petition for review, and we want to clarify that this order should have been automatically stayed as a mandatory injunction by the appellate court. And in a unanimous opinion by Justice Kruger, she goes through and traces the rule and talks about the stay provisions in the CCP, the history of them, the common law application. And she recognizes that, look, the default rule is that court orders get enforced, and they're enforced in proceedings. The exception is an order that directs someone to do something, a mandatory order. That's an exception. That's not the general rule. And the exception is tied around preserving effective relief on appeal. If a court order directs someone to go out and do something and you appeal it, and that order is not stayed, chances are that appellate relief is going to be limited effect, and it's not going to be very satisfactory in the end. So
one of the examples that the court gives is if someone is supposed to remove a tree from that's blocking someone else's view. Well, if you don't stay that pending appeal, then the appeal of an order directing you on that issue is wrong, and well, it's sort of fruitless. I'll make one other comment. Justice Siggins said that there haven't been a lot of cases on this, certainly at the Supreme Court level. The first 4 Supreme Court cases that this decision cites are from 1857, 1889, 1881, and 1883, which is, and a Supreme Court decision is precedent no matter how old it is, if there hasn't been anything overruling it. But ordinarily, we don't have to go back that far.
Right. So to pick up on your point, Don, she Justice Kruger's opinion, she talks about the nature of the rule, what we're trying to do. And she says, but the difference between mandatory and prohibitory is not always easy. And she says, you got to look for certain benchmarks. And one, she says, in order to remove improvements to property, the tree case is a mandatory injunction. But in order to refrain from using an easement, to refrain from walking across a piece of property, well, that's prohibitory. And so she kind of lays these out, and then she comes to the cases dealing with employment and board membership. And she says, typically, they require a member to surrender their positions, and those are mandatory cases. Likewise, contractual cases that require the defendant to act in a way that's not specified in the contract, those are mandatory cases. So, the bottom line here, I think, is no surprise that this is a mandatory injunction. It's removing someone from office, and it's not stayed. And I'm sorry, it is thus stayed during the pendency of this appeal. The other thing that I think is interesting about this case, and it's the first time I've seen it really. Peter,
it's stayed, and therefore the lower courts have no business making any further adjudication while it's stayed.
Correct, during the pendency of the appeal.
Yeah.
And the other thing that's interesting about this case that is unusual is, or not unusual, but is expositive, is that she talks about where you measure the status quo from. And very few cases talk about that. And here she says courts typically consider the status quo with reference to the time the order was entered. She says, but that's not always the case, nor should it always be the case. She says, if it's an order directing the defendant to desist from an ongoing pattern of bad conduct, unlawful conduct, she says, then you should look to the time before the disputed conduct started. And it's a great phrase. She says, we look to the last actual peaceable, uncontested status between the parties, which in some cases maybe never. But anyway, she says, you look back to the time when peace reigned, if what you're really talking about is making the defendant stop some bad conduct. So here, facially and in substance, she says, this was an order to rescind an appointment. It's a mandatory order. During the pendency of appeal, it stayed. And there you go. That's
this case is unlike Sandoval, which directed the Judicial Council saying the law is wrong, so you should change it. Justice Kruger has a section in this which says, well, the legislature, you should revisit this and perhaps allow a more flexible approach that permitted the trial courts and appellate courts to weigh the likelihood of each party's success on appeal in determining whether or not to stay in action, and points out that that is the case in some other jurisdictions. Maybe the difference between here and Sandoval is in Sandoval, the Supreme Court can direct the Judicial Council to go do something, whereas here they can't really direct the legislature to go pass a new statute.
Yeah, and I will tell you, I don't see this as having the kind of gravamen that's going to attract the attention of the legislature or, frankly, the organized bar in a way that there's going to be enough of an uproar to go into the legislative process on this point.
Don, why don't we go to Farah versus Lowe's Hollywood Hotel?
So the two cases I talked about before both end up with results against workers. And so people might think, well, what is our Supreme Court doing? They're anti-worker. Well, here's a case where the Supreme Court rules in favor of the workers. And the issue here involves payments for an employer failing to abide by its duties. There's one statute that says that in calculating overtime pay, the employer has to compensate an employee by a multiple of the employee's regular rate of pay. There's a different statute. If the employer doesn't provide the employee with meal and rest breaks or recovery periods, the employer must pay the employee an additional hour of pay at the employee's regular rate of compensation. So the question is, are regular rate of pay, compensation and regular rate of pay the same thing? And traditionally, it was considered, well, regular rate of compensation, that is your hourly rate. The employer made the perfectly facially reasonable argument that, well, the two statutes dealing with similar topics are using different words, therefore there must be different meanings. But the court held not always and not in this case. Here, Lowe's paid their bartender hourly wages as well as quarterly non-discretionary incentive payments. And then she filed a class action saying that the employer had omitted the incentive from its calculation of the meal and rest periods. The trial court said, use the hourly rate. The Court of Appeal, a split Court of Appeal, agreed. And it was the dissenting opinion in the Court of Appeal that got cited over and over and over again in the Supreme Court decision. What the Supreme Court said was a couple of things. Yes, there's a principle of construction that when different words or phrases are used in the same connection, it is presumed that the legislature intended a different meaning. But there's another canon of construction that says,
aren't there dozens of those?
Well, there's another one that directly addresses this one that says, where statutes use synonymous words or phrases interchangeably, those words or phrases should be understood to have the same meaning. And the court then focused on a couple of things, and one that is more generally applicable is that in both those statutory constructions, there was the phrase regular rate. And that was the important part, not of compensation or of pay. How can that be if compensation and pay are different words? The court addressed that in a couple of ways. One, it said, and this is also facially reasonable. Compensation and pay sound an awful lot the same. And why should we interpret one of them differently than the other? And the other way, which is much more scholarly, was the court went into the history behind the wage orders that came up with that resulted in these two statutes, and found there that the focus again was on the regular rate portion of those two phrases and not what came after them. So because of that similarity in regular rate and because of the history of the statutes, the court decided, well, the canon of construction to follow is the one that says that we're going to understand these things to have the same meaning, not the one that says if there's a small difference in the wording, we're going to decide that that has huge differences. Again, sort of the beyond this case importance of this is the court said, canons of interpretation are not immutable rules. They are guidelines subject to exceptions. And here, that was proper for the exception. The other employment-specific part of this for the employment lawyers out there is that the court said, if we didn't interpret it this way, then employers could structure their payments differently, and people would end up with different results. If I pay you a high regular rate and no incentives, you get one result on your violations for meal breaks. If I do it a different way, then you get a different result. And the court found that the history of this statute, of these statutes and of labor law in general was, no, we want to treat workers the same. We don't want to draw a distinction between piece workers, for example, and hourly rate workers. We want to protect them both. Another aspect of this decision that is significant is its discussion of retroactivity. And the employer argued, well, this is such a huge change in the law, it should only apply prospectively. And the Supreme Court had a couple things to say about that. One was, what are you talking about, huge change in the law? Just because you were interpreting the statute based on one canon of construction doesn't mean that was what the law was. You could have also looked at the same canon of construction we did here and thought that it would be another way. Another one, and this refers to, I know I see this from defendants in other cases a lot of times. Well, this decision will have a huge effect because it's going to expose employers to millions of dollars in liability. And the court said, well, first, there's no evidence of that. That's argument. And second, even if they're correct, it is not clear why we should favor the interest of employers in avoiding millions in liability over the interest of employees in obtaining the millions of dollars owed to them under the law.
Well, maybe we can go ahead, Peter, if you want to add a quick note and we'll move forward.
No, I just think that, the court was struck, I think, significantly by the facts of this case, that these were regular periodic payments. This was something that if you showed up, you did your job, you were going to get. It's not a discretionary bonus.
Right.
Compensation package. Yeah.
And I think the takeaway for litigators is if you're confronted with a canon of statutory construction that you think is going against you, keep looking, because there's often an equal and opposite canon that you can latch onto and base your argument. And in this particular case, it worked. Let's talk about the latest anti-SLAPP decision from the California Supreme Court, which is Bonney versus St. Joseph Health System. And Bonney is a case in which the plaintiff was undergoing peer review. It's another case where the plaintiff's rights and privileges at the hospital were being reviewed. And as a result of that review, which was unfavorable, he brought a lawsuit against the hospital. And of course, the hospital immediately filed an anti-SLAPP motion because in other contexts, the Supreme Court has said that the anti-SLAPP statute applies to peer review proceedings. And in particular, that was a case from 2017 called Park, in which a university professor had filed a lawsuit alleging that the denial of tenure and other actions that the university took against him were based on discrimination and other illicit motives. And in Park, the court said that yes, the anti-SLAPP statute can apply to a lawsuit that involves peer review. The reason this case came up is that there was a prior Supreme Court decision called Kibler, and Kibler had been read by some courts as creating a shield as to the anti-SLAPP statute. Some courts had concluded, based on broad language in Kibler, which came out before Park, that peer review proceedings were not something that the hospital could apply the anti-SLAPP statute to. And in this particular instance, the court is sort of clearing up that tension in the courts and saying, no, hospital peer review is the same as any other peer review, and lawsuits are the same as any other lawsuits. And if the lawsuit bases liability on protected activity, meaning if the lawsuit says that the liability arises because of statements made by those at the hospital conducting the peer review, then the anti-SLAPP statute can apply. But like other recent cases, there can be another reason that the plaintiff points to comments made in peer review. And that other reason can be that that's proof, that's evidence of either racial animus, discriminatory animus, something in the discrimination and wrongful termination or retaliation in the case of whistleblower complaints, pointing to the comments made in peer review as evidence to establish the illicit intent or the discriminatory animus. And in that case, the anti-SLAPP statute does not apply because protected activity is not the basis for liability. Now, I just want to talk about that distinction because this really is another case based on the line drawing that the Supreme Court has established for anti-SLAPP cases. And what happened 3 years ago, 5 years ago, 8 years ago, was courts were tending to try to find the overall gravamen of a claim or the overall thrust of a claim, something the court refers to in Bonnie as an exercise in metaphysics and other conjuring. And in the wake of those cases, the California Supreme Court created a bright line. And the bright line is that when protected activity forms the basis of liability, when it is alleged to be the reason the plaintiff can recover, and not just evidence supporting the claim, then the anti-SLAPP statute applies. Well, how does that work in reality when we all know that a single claim can be based on multiple allegations, many of them involving peer review in this case, and comments made and actions taken in peer review? And the Supreme Court reminds us, as it did in another recent prior case, Barrel versus Schnitt, that courts must, and the moving party must, they have the obligation, they have to sift through a particular claim, and they have to point out to the court which of these allegations involving, in this case, peer review, are alleged to be creating liability in and of themselves, and which are not. And the ones that are alleged to create liability in and of themselves can be responded to with an anti-SLAPP motion, can be stricken upon that proper showing of protected activity, unless under prong 2, the plaintiff shows a reasonable probability of prevailing on the merits. But the question here in this case was prong 1. What part of the plaintiff's claims, and it seems like it always is, what part of the claims in a cause of action alleging a litany of facts is basing liability on protected activity and which is not. And what the court did in this instance is it went through and it found that some of the particular allegations, after it found that the privileges should be suspended and the reasons for it, the peer review board had a mandatory duty to report to California Medical Board that these findings had been made, which of course is akin to a lawyer being reported to state bar. And that allegation was absolutely protected conduct. And in this particular complaint, the plaintiff was saying they should be liable for reporting me. So that's basing liability on protected activity. And it was proper to bring an anti-SLAPP motion in response to that. And it was proper to say that the defendant satisfied prong one. Also, comments made during peer review that we might think of, oh, he's saying these are defamatory. He's basically saying these are defamatory, these statements, but they were comments about his behavior, his handling of his patients, his medical practice in peer review. And when he's saying these are essentially defamatory, that's protected activity. But as with all discrimination cases, there were a lot of other facts here, a lot of other allegations supporting this claim of wrongful termination. And the court says those are being referenced or alleged as the evidence in support of the discriminatory animus. And I'll let the guys jump in here, but I just want to point out what Justice Groban points out in his concurrence, because it's very interesting. He points out that you can have the same evidence. You can let's call it the same allegation. You can have the same allegation, and there's some tension or some irony in the fact that how we characterize what that allegation is in there for will decide whether your anti-SLAPP motion is successful, or at least it's cognizable, and the plaintiff now has to show a probability of prevailing. But if it's characterized more generally as just evidence supporting the claim, and that's what the court feels when it's reading this, then you deny the anti-SLAPP motion as to that evidence or those allegations, and there's no pre-screening for merit that happens here. And what Justice Groban says is you still have this leeway in the way that the complaint is pleaded that has the irony of allowing the plaintiff to get around it by simply characterizing or arguing its evidence. It's not the basis for liability. But I think this is where we are, because it's very hard to have a bright line rule in the anti-SLAPP statute. And the one that's currently in play in every case in a mixed cause of action is which allegations are alleged to have created liability in and of themselves. Just the very fact that these allegations, these statements were made, creates liability. Think again of defamation or defamatory statements. That's the bright line rule. And then if it's discriminatory animus, Justice Groban is writing, there's tension here about the same evidence is still going to be in the case. It's not like you can never refer to that evidence again. You just can't base liability on it, but you're still going to go forward and say, well, this evidence also points to the discriminatory animus. The floor is yours.
Don, do you want to?
I'll jump in and say two things. One is that in some ways, this case did not seem to me to be all that different from one of the cases that Gary talked about, Park versus Board of Trustees. It really reaffirms the rule in Park that the anti-SLAPP statute protects speech and petitioning activity taken in connection with an official proceeding. But it doesn't necessarily protect the decisions made or actions taken as a result of the proceeding. So in Park, it might have had an effect if what he was suing about was what was actually said. But what Park's case was all about was, I was discriminated against. I was denied tenure on the basis of my race. And that is not protected by SLAPP. The other point I would point out here is, and again, mostly for the employment lawyers, is a notion of whether discrimination and retaliation claims should rarely, if ever, be appropriate targets of an anti-SLAPP motion. And the court discusses that in the context of this case and of Wilson versus, I think it was CNN News, and says, well, that's true, but the legislature remains free to adjust the statutory scheme's application to discrimination and retaliation claims if it so chooses. And while there's probably not a lot of legislative will to make the push on mandatory and prohibitory injunctions that we talked about sooner, our legislature has been very active in protecting employees in a wide variety of ways in the last few years, and they may consider that here.
Now, guys, we have time for one more case here. And what I'm going to do is offer it up to anybody who wants to talk about one of their cases. Peter, why don't we see if there's one that you in particular want to address in about 4.5 minutes?
Yeah, in 4.5 minutes, I think I can and would like to anyway, talk about Facebook versus Superior Court. I think that's something that people need to be aware of, pay attention to. This is a case that deals with a subpoena ducis tecum served on Facebook as a third party for statements and private messages and private posts, restricted posts of a crime victim. And essentially, the court took the case because they were considering whether Facebook should have protection under the Stored Communications Act and to consider the constitutional issues that arose. But it appears that in the course of working the case up, the court looked at a sealed declaration and some exhibits that were provided in camera to the court when the subpoena ducis tecum was challenged. And in order to overcome a motion to quash, you have to demonstrate that the subpoena ducis tecum was supported by good cause. And in conducting its review, the court realized or stated that, we've never really said what the test is for good cause on a third-party subpoena ducis tecum, and we ought to articulate it. We will articulate it. And they look to an earlier case by Justice Krosky, a 1988 case from the Court of Appeal, and they say, there are 7 factors that you have to consider in determining whether or not there's good cause for a subpoena ducis tecum, a third-party subpoena ducis tecum. 1, has the defendant shown a plausible justification for getting the documents from the third party? And they say this is more than a desire that you need them. It's more than saying you want to look at whatever the prosecution has, or these are important to me. You really need to demonstrate that they will assist the defendant in preparing a defense. The second factor is the material adequately described and not overly broad? The third factor, is it reasonably available to the subpoenaed entity and not available otherwise to the defendant? And then the fourth factor, they also illuminate a little bit, and they say, would production violate a third-party right to confidentiality or intrude upon a protected governmental interest or a government-protected interest? And then they say, look to a substantial connection between the information that's sought and the underlying criminal activity. The last 3 factors are if the request is timely, would the time required, the 6th is would the time required for production unreasonably delay the trial, and the 7th is would production unreasonably burden the third party? And after they run through those factors, the court remands it back to the trial court because they for further application and consideration. And they also point out that this was considered by the court in camera, and they make clear that in-camera proceedings are disfavored on these subpoenas, that unless you're really trying to protect privileged information, you should not be proceeding in camera. And ultimately, I want to just make one more comment. The court in the past has frequently reversed and remanded cases to the Court of Appeal. And this case, they remand with directions to the Court of Appeal for a further hearing on the motion to quash. I've noticed that in several Cal Supreme cases this year. I think it's a positive development, because when the cases are normally remanded to the Court of Appeal, there has to be further briefing and another round of an opinion or an order. And in many cases, that really they reverse, and the further action has to take place in the trial court. And I think the court is starting to be very cognizant of that and careful in the way it's sending. And I would urge you that when you have cases in front of the appellate courts, be very specific about that kind of relief.
Well, Peter and Don, the 1 hour goes really fast. I want to thank you very much for these insights today. And I want to thank everybody for hanging in there with us for this sort of, speed race through the recent California Supreme Court decisions. And if you do have any questions, please follow up with us afterwards. We're always happy to talk about these cases or any other cases. Just reach out to us after the event is over. Thank you very much.
Thank you all very much, Justice Siggins and Gary and Don. We really appreciate your expertise and thoughts on all of these. And actually, you will have attendees, you will have a chance to chat directly with the panelists in just about 2 shakes of a lamb's tail after I give a couple of announcements. There'll be a live Q&A after this. So just real quick reminder of where you can find the materials and evaluation forms. Through the Files tab above the chat, and attendance certificates will be available after the Thanksgiving holiday. If you have any questions about that, check out the FAQ tab, and you can also get technical support there as well. All right, so now please click on the link below and join us for the live Q&A with our wonderful panelists. I'll see you guys there. Thanks again.